Good morning and welcome to the Shenkman Private Client Group Accountant Attorney Spring Webinar Series. This program is entitled Death, Divorce, and Assisted Reproductive Technology, Estate Planning and Family Law Considerations. For those who don't know me, my name is Jonathan Shenkman. I'm a financial advisor, portfolio manager, and an accredited investment fiduciary at Oppenheimer based in New York City. The goal of all my programs is to bring professionals together to help them better serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 25 or so events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. You can read my work in Barron's, CNBC, Forbes, Kiplinger, the Wall Street Journal, the CPA Journal, Trust and Estates Magazine, and many other periodicals. After the program, I'll send out a link to all the publications where I publish my work. One quick note before I introduce our esteemed speaker, which is the handout to this program was sent out within the reminder email yesterday morning and this morning as well. Will also be sent out again in the follow-up email to this program tomorrow morning. Today, we're privileged to hear from Alexis Cirel, who is partner at Warshaw Burstein, based in New York City. Alexis works in the matrimonial family law group at the firm, where she is a leader in the evolving area of reproductive family law. She was instrumental in the recent passage of the Child Parent Security Act, legislation that legalizes gestational surrogacy in New York and ensures protections for New York families formed through the use of assisted reproduction, including being appointed to the campaign leadership committee to pass the law. Alexis is deeply committed to providing compassionate legal advice to all clients, whether they're going through a marriage dissolution or embarking on an exciting but complicated journey to building a family through a third-party assisted reproduction arrangements. Prior to joining the firm, Alexis was a partner at boutique matrimonial firm and a senior litigation associate at Canton, based in New York City. Today, Alexis will be speaking on death, divorce, and assisted reproductive technology, estate planning, and family law considerations. With that introduction, I'll now turn the program over to Alexis.
Thanks, Jonathan. Hi, everybody. Good morning. I was going to start with a background, but Jonathan did a pretty good job. So just again, I'm a family law attorney in New York City. I practice in the areas of both matrimonial law and fertility law or family building through assisted reproductive technology. I'm also a parent through surrogacy myself. So I have both professional and personal familiarity with some of the issues we'll discuss today. I am really thrilled that members of the Trust and Estates Bar have shown so much interest in today's topic, because the prevalence of families conceived by means of assisted reproductive technologies today is really undeniable. The latest stat I have is still a little outdated, but according to the CDC, there were almost 90,000 babies born as a result of assisted reproductive technologies in the US in 2018 alone. So much of my practice really implicates trust and estates issues, and I've come to realize that dealing with these issues is such an integral part of a holistic approach to family law that my trust and estates colleagues are on speed dial for me. I imagine that the inverse is also true, so that you trust and estates practitioners probably will increasingly, if you haven't already, come into contact with assisted reproductive technology, or I'll call it ART for short, issues. I want to give you a brief introduction to some of those issues today. It's a short program, so I'm only going to go over a few of the topics on a pretty high level, but do please feel free to reach out to me to request materials or other questions. My emails should be on the screen now. And I will start with some basics. So just to go over a little bit of the science and the background so that the terminology is familiar today. So we know we make a baby by combining a sperm with an egg and a uterus to gestate the pregnancy. When the sperm and the egg combine, the resulting mass is called an embryo. We'll talk about embryos today. And it's that embryo that would then implant into a woman's uterus and result in a pregnancy. When children are conceived using traditional means, all of this happens naturally inside the woman's body. When we're talking about assisted reproductive technologies, like in vitro fertilization, all of these same steps of conception occur, but they're broken down into component parts, and they occur outside of the woman's body in the laboratory or medical setting. So how is this done? A woman's eggs are surgically retrieved. They're fertilized in a petri dish in a lab setting with a sperm sample, and the resulting embryo can then be surgically transferred into a woman's uterus. More recent scientific advances also now enable reproductive genetic material, so eggs, sperm, and resulting embryos, to be cryogenically preserved and stored for later use. So with the ability to isolate these component steps of conception in a lab setting, ART, assisted reproductive technology, really enables third-party participants to the creation of life, like, for example, a sperm donor or an egg donor who have no intention of being a legal parent of the child that results. And it also, the ability to freeze and preserve genetic material also enables the ability for posthumous conception or conception after the death of an intended parent. Now, a central legal issue implicated by all of this is the question of legal parentage, children conceived using these assisted reproductive means, and whether it makes sense to determine such parentage with reference to traditional legal assumptions based solely on, for example, a genetic connection to the child or the act of gestation. And while the law in this area is developing rapidly and varies to a large extent state by state, there are some main themes that have emerged, one of which is pretty consistent, that when we think about legal parentage of a child conceived through art, we think about it not with respect to genetics or gestation only, but more so with reference to preconception intent and consent to be a parent. So why does this matter for you trust and estate lawyers? Well, the implications of how we conceptually think about legal parentage are really far-reaching, and especially in the context of death and divorce, which is what we're going to talk about today. So, for example, given that we can store genetic material for procreation after death, under what conditions can genetic material that's been cryogenically preserved be used by an intended parent who is deceased? Will a posthumously conceived child be legally recognized as the decedent's heir for purposes of inheritance or eligibility for survivor benefits, for example, and under what conditions? What becomes of a couple's frozen embryos in the event of divorce? So these are all some of the issues that are implicated. I'll break them all down here today, but it's important to note really that the first step in any analysis when we're thinking about disposition of genetic material on death or divorce is an analysis of what we call preconception clinic forms. Sometimes they're referred to as advanced directives. Essentially, these are forms that all patients who undergo assisted reproductive technology are required to complete at the fertility clinic or at the cryobank where they're undergoing the procedures. The forms designate dispositional intent, and that essentially instructs the IVF clinic or the storage facility how to handle the cryopreserved genetic material in the event of death, divorce, or separation, the options being either to destroy and discard it, donate it to research, donate it to another individual or couple for procreative use, or to grant sole control over the genetic material to a particular person and the authority vested in that person to use the genetic material for reproductive purposes. I skipped a slide there, I apologize. So starting with the question of whether a decedent's genetic material can be used for reproductive purposes, and I'm talking now use, not necessarily legal parentage. There are no federal regulations or statutes that govern disposition of cryogenetically stored gametes, sperm or egg, or embryos upon death. So this question is really resolved with reference to piecemeal state legislation and some slowly developing body of decisional law that has addressed it. The decisional law, again, usually arises in the context of a deceased individual, the parents or a spouse, I'm sorry, of a deceased individual who are seeking to use the stored genetic material to conceive a grandchild or a child of the marriage post-death. In these cases, the courts are called upon to look at the expressed intent. Again, usually this is found in the clinic form of the decedent as to how the genetic material can or cannot be used after death. I have a few sites to some authority here. We don't have time again to go through all of it, but I'm happy to email any of these decisions to you. But you can just see by looking, for example, in Speranza, the top case, the couple was not able to obtain the release of their deceased son's frozen sperm to produce a grandchild via surrogate, where the clinic form instructed the IVF clinic to destroy the sperm in the event of his death. So again, the results are not consistent. They vary to a large extent, but we do see some trends. I'm going to not spend too much time on this particular issue, posthumous retrieval of gametes. This kind of goes into the same category of use of genetic material after death, but it takes it one step further and talks about how you can actually retrieve those gametes if they're not already stored somewhere after death. I have some case sites here. Happy to share that with anybody if you are interested in this subject more. So now turning to the legal parentage piece, distinct from the issue of posthumous use is really whether the child who's conceived posthumously is the legal heir of the deceased and stands to inherit from the deceased or is entitled to survivor benefits. Case law in this area principally arises in the context of claims for Social Security benefits. In 2012, the Supreme Court resolved a split among our circuits in Astro versus Caputo, holding that the eligibility of posthumously conceived children to receive Social Security survivor benefits is determined with reference to applicable state intestacy law. Now, most states don't have express statutory provisions on this issue, but for those that do, and in the small body of decisional law that address it, there are some emerging trends. First, the statutes and the judicial decisions that resolve these issues seek a balance of competing interests between beneficiaries and the provision of orderly and timely administration of estates and the protection of the reproductive rights of the deceased parent. Second, written consent of the decedent to the use of the cryopreserved material, as well as to the support of the resulting child, is generally required. Third, some reasonable time limit is usually imposed to ensure that the estate does not remain open indefinitely. And finally, in some cases, there is legislation or there's been decisional authority on posthumously conceived children using donor genetic material. So that's getting a little bit more complicated, but essentially saying if there's an intended parent who created embryos during his or her lifetime with donated genetic material, donor eggs, donor sperm, and intended to be a parent of a resulting child, if that child is conceived post-death, the child can still be eligible to inherit and to recoup survivor benefits from the intended parent. Then I have a few case law citations here if people are interested. We don't have time to go into too many of them, and I've just included two so you can see how different courts come out different ways. So in the estate of Colossi, the New Jersey intestacy statute did not address inheritance rights, the posthumously conceived children, but the court did rely on a legislative intent that children should inherit from their parents through intestacy to conclude that the genetic child of a decedent should be treated as an heir in that case. On the flip side, in Finley versus Astru in Arkansas, in Arkansas intestacy statute was interpreted, and a child born from an embryo there was not entitled to participate in the surviving, but was not entitled to inherit from the decedent intended parent. Excuse me. So some states like New York do have prescriptive legislation on the issue of posthumous parentage, and I thought it might be helpful just to look at New York statute here as an example of what a comprehensive legislative scheme looks like. So under New York law, our Estates, Powers, and Trusts law, section 4-1.3, and a concomitant statute, which is a new law in New York, the Child Parent Security Act, which is codified in the Family Court Act, Article 5C. A child conceived through assisted reproduction is in fact a distributee and included in the disposition of property, where it's established that the decedent intended parent expressly consented in a written instrument executed no more than 7 years prior to death, that if the assisted reproduction were to occur after death, he or she would be the parent of the child. The child in this case would have to be in utero no later than 24 months, or born no later than 33 months, after the intended parent's death. And the decedent intended parent must authorize an agent to make decisions in that written instrument about the disposition and use of the genetic material. Notably, the appointment instrument under the New York statute may not be altered or revoked by a provision in the will of the intended parent. And so an agent, if the authorized agent is a spouse, the written instrument is revoked by a final judgment of divorce. So this essentially is saying that in New York, you cannot dispose of genetic material by will or trust instrument. And really the disposition of genetic material on death is left solely to the province of this statute, or these two statutes together, in conjunction with, once again, clinic forms that are signed pre-conception. So moving on to the issue of embryo disposition on death and divorce, which is really gets much more attention and a little bit easier to conceptualize. It's really one of the most prevalent issues that I see in my practice right now. There are so many thousands of individuals, who have created embryos through IVF with a former partner and spouse, and they're stored, cryogenically stored across the country. And it's no surprise, of course, that disputes arise as to how to dispose of this in the event of a separation or the dissolution of a marriage. In some situations, one party who was a former intended parent at the time of creation of the embryos doesn't want to have a child with the other party. In some cases, the non-consenting parent is okay with the former spouse using the embryo for procreative use, but doesn't want to be a legal parent, i.e., doesn't want to have support obligations, doesn't want to have parental responsibility. In some cases, it's an individual's lost opportunity to achieve biological parentage, whether it's because of age or some medical condition, for example, oncological treatment that renders somebody fertile. So the legal and ethical questions here are really vast. And the biggest one being, is one party's interest in becoming a genetic parent outweighed, or does it outweigh another party's interest in avoiding forced parentage? So here again, some judicial trends have evolved across the country in resolving disputes arising in this context. First, embryos are generally treated as neither persons nor property, but a special class of their own, some quasi-property characterization. This concept is articulated first in seminal case of Davis versus Davis. I have the citation there. It should be on the screen. If it's not, Here we go. So what does this mean? Well, it means that generally embryo disputes are not analyzed from the perspective of best interests of the child analysis, and not necessarily addressed as it would be for equitable distribution of marital property, for example, because these embryos are in the class of their own. So how do courts analyze disposition of embryos in the event that there is a dispute? The starting point again for the analysis, preconception clinic forms, which we already covered, designate a patient's dispositional intent. But courts have really struggled with, whether strict application of the dispositional selections that are made in these forms at the time when, for example, a couple is happily pursuing procreation together, whether they should really be binding. In some cases could be years, decades, whatever later, after intervening change in circumstances like a divorce. So depending on the state, the jurisdiction, courts utilize essentially three different analytical frameworks in the approach to resolving these disputes. The first being a strict contract approach, which essentially just looks at these preconception intent forms at the clinics or any other agreements between genetic contributors to an embryo, and strictly enforces what the selections made there are. In other jurisdictions, there is a contemporaneous mutual consent approach, essentially that notwithstanding what was selected preconception, at the time the dispute is being resolved, so contemporaneously, do both parties agree to how it will be disposed? If not, status quo remains, meaning usually the cryopreserved state is perpetuated. And or three, a balancing of interests approach. I'd say that most recently, the biggest trend is kind of a confluence of all three of these analytical frameworks. And so we're seeing now mostly courts deciding these issues by enforcing clinic forms or other agreements between parties, but while giving the parties the option of mutually modifying the agreement later. And if there is no contemporaneous agreement that can be achieved, then balancing the interests. Generally, forced parenthood is disfavored, and so the party who is opposing use of the embryo for procreation will prevail in these disputes. But there's been some case law where these special circumstances tip the scales in favor of the party who wants to use the embryo for reproductive purposes. For example, if they have undergone oncological treatment and can't achieve genetic parenthood any other way. I wanted to again just give an example from New York law. Here you go, of some legislation, some recent legislation that we have enacted here in New York as part of our Child Parent Security Act that seeks to address some of these issues and hopefully mitigate litigation when it comes to disposition of embryos in divorce. So we have Family Court Act section 581-306 essentially provides that spouses, former partners who have joint dispositional control of embryos now have the ability to enter into enforceable agreements, transferring legal rights and dispositional control from one to the other. In these cases, the agreements must be in writing, independent counsel for both sides. And if the couple is married, the transfer of legal rights is not effective, does not actually occur until the judgment of divorce is issued. Now, what's the upside to this? The upside to this is that we are essentially treating a former intended parent, i.e. the party who doesn't want to use the embryos for procreational use. We're treating that person, that individual now as a donor. So there's no legal parentage obligations affixing, and it's not going to violate public policy, for example, to say that this person will never have support obligations for any child that's later conceived from the embryos, because we've now transferred all legal rights and parentage authority to the other parent, and the former intended parent is now a donor. So again, I'm seeing a lot of this in my practice. It's new and we're still testing it out and playing with it, but it's, at least in my experience, I've been able to resolve what otherwise would have been probably mediated or litigated disputes in this area with the ability to enter into these agreements. So I wanted to just wrap up with some practice pointers, because again, everything is still new and developing here, but we can draw from some of the trends that we've seen to see how can we start as family law practitioners and trust and estates lawyers in particular, how do we start to just get ourselves into the modern age and be prepared to address some of these assisted reproductive technology issues with our clients. First, carefully and specifically tailor the definition of distributees or issue in wills and trusts, right? So you want to be deliberate. You want to ask your clients, do they want to include, do they want to exclude ART conceived children, for example? Does that include donor conceived children? Does that include posthumously conceived children? These state planning documents really should specify and address inheritance rights under all of these conditions. I'm going to just go through quickly this matter of Doe, just because you can see here how it manifests as so critical in daily practice. So in that case, there was a trust created in 1959, prior to assisted reproductive technology, of course, and for the benefit of the settlers' issue or descendants. And it specifically stated that adoptions shall not be recognized. There, the settler's daughter and her husband entered into a California surrogacy agreement in which eggs of an anonymous donor were fertilized with the settler's daughter's husband's sperm and carried by a gestational surrogate, and twins were born. The California court issued a judgment of parental responsibility, legal parentage, establishing that the settler's daughter and her husband were the sole legal parents of the twins. So the question that the New York Surrogates Court was called upon to resolve was whether these twins were issue or decedents of the settler's daughter and therefore beneficiaries of the subject trust here. And the New York Surrogates Court here accepted the California judgment and said that this is distinct from adoption, and did indeed determine that the twins conceived in this way were beneficiaries of the trust. Last few points. Powers of attorney. You should definitely look at your powers of attorney forms, talk to your clients if there's going to be a potential for assisted reproductive technology. If there has been, you want to make sure you address stored genetic material in powers of attorney. You want to make sure that your clients understand what's out there, what have they signed, what clinic forms are there, what contracts are there that will govern the rights to their genetic material, including in the event of death and divorce. In states where it's permitted, so not New York, testamentary documents really should provide for the disposition of genetic material at death and be consistent with these fertility clinic forms and any other forms that are completed addressing this issue. We've talked about that. Beneficiary designations. So it could be that custodian's definition, for example, of issue or distributee is different than what's intended by your client, so that it doesn't contemplate ART conceived children. So you want to look at your beneficiary designations and have your clients update them to include children conceived through ART if that's their intent. And finally, if a client uses ART or intends to use ART, have they disclosed this to their family members? So, talking about family members' estate planning documents that may also need to be modified as necessary to include ARC conceived children in estate planning. So that's really all I have for today. I am very happy to share thoughts, references, whatever it is. If people want to email me, I'll put the email back up here. And thanks again, Jonathan, for having me.
Great. Thank you so much, Alexis. If anybody has any follow-up questions or new business opportunities or any other issues that they'd like to discuss, you can feel free to reach out directly to Alexis or myself where appropriate. And I'll be sure to include her contact information again in the follow-up email to this program. As I mentioned at the onset, the goal of these programs is to stay up to date on timely wealth management topics and to collaborate where appropriate. I think we can all agree that the clients who are best prepared are the ones who are served by a team of knowledgeable advisors. Two more quick items before I let you go. First, my next program will be on Thursday, April 28th, a New York tax update post-COVID-19 featuring Timothy Noonan, who's a partner and tax residency practice leader at Hodgson Russ based in Buffalo, New York. Second, please take 30 seconds to fill out the survey at the end of this program. It helps me improve my webinars and provide timely and interesting content to attendees. I thank you in advance for that. And with that, this concludes today's session. Please stay safe and healthy and have a wonderful day, everybody.